Hello, everyone. Hey, I just saw this on my feed just now. I didn't know this was happening. Apparently, we've got opening arguments. In this case, happening 3 p.m. Nevada time. So that's supposed to be happening. And yeah, so this is apparently happening now. New York versus Deborah Reardon. A guy he jumped at the judge. He jumped at the judge in open court, man. As he's being sentenced, he did a flying leap over the bench and attacked the judge. Anyone remember that guy? I remember that guy. Apparently, opening arguments in his trial are happening today at 3. I'm excited. It's pretty late in the afternoon, but I guess that's what we're doing. We're doing opening arguments at 3 o'clock in the afternoon. Don't ask me why. We just apparently are. I don't know. That's what we're doing. So I'm excited about this because this guy is insanely guilty. It was caught on camera. He jumped over the desk and beat up the judge and beat up the clerks and beat up everybody. And yeah, he's all the guilty. We watched it happen. We watched it with our eyes. So he's incredibly, insanely guilty. So I look forward to the opening argument, which I'm sure will be very illuminating. Yeah. He Supermaned it. He did. He Superman that thing hard. He absolutely Supermaned it 100%. Oh, Lord. I'm going to just see if I can find an image of him doing it real fast because I need to create a thumbnail for this. Deborah Reardon. A man named Deborah. Maybe that's part of the reason that he did it, because he's a man named Deborah. Oh, yeah. There we go. There's the image of him doing it. Oh, yeah. Got to update the thumbnail, man. A man named Sue. Poor Deborah. Yeah. His mama may have hated him. Yeah, that's possible. His mama may have hated him. That's okay. We all hate him too. What a character he is. He is so much fun. Oh, yeah. I'm just updating my thumbnails real fast as I wait for the court to start. Because I didn't know this was happening. It just like crossed my feed. I'm like, ooh, I didn't know that was happening. What a tool. All right, what do we call this thing? All right, what do we put on the thumbnail? I need 4 words to put on the thumbnail. Deobra, he prefers Deobra. All right, we'll call him Deobra. Deobra then. Deobra. We'll go with Deobra, fine. If he prefers Deobra, we'll go with Deobra. Do you see he pled guilty to 6 out of 7 charges, but not attempted murder? I didn't see he pled guilty. I don't know why he would plead guilty to 6 out of 7, but plead not guilty on the 1 and go forward. That's a very odd thing to do. To my mind, it's a very odd thing to do. He was just objecting. He did object very hard. No, I didn't see that he pled guilty. It's a very odd thing to me to plead guilty to some charges and not plead guilty to all, to not dispose of the entire case. That's a very odd thing to do. I'm curious why he did that. I'm sure he and his lawyer had a strategic reason, but I'm not sure why. So what do we put on this thing? He's pleading not guilty by reason of insanity. Fuck no. No, absolutely not. No, he was completely sane. I watched him be completely sane. I saw him be completely sane. He's pleading NGRI? Fuck no. He lost his temper. That's not NGRI. He's so fucking guilty. He's incredibly guilty. Flying, okay, we'll call him flying defendant. Flying defendant. Yeah. I watched him. He's sane. He just lost his temper. It is not the same thing, man. Flying defendant. Flying defendant. Let's see. I need to like change this font. Okay, I need to change this to make the same size so it'll look right. Let's see. This is 80. We'll change this to 83 flat. And change this to 83. Oh, by the way, this is also a good time. Someone sent me new screws for my SM7B. The ones that are supposed to be there from the factory. So they're nice flat black. So someone sent me new screws. So I just installed those. So to whoever sent me those to my P.O. box, thank you. Because those look nice. Flying defendant pleads insanity. All right, that's good. Yeah. Flying defendant pleads insanity. I like the rigs. I like the rig too. Flying defendant pleads insanity. Or maybe flying defendant opening arguments. Yeah, flying defendant opening arguments, because apparently that's what we're doing. Ladies and gentlemen of the jury, my client is insane. Fly me back to prison. I know, exactly. I know. I know. Excuse me, guys, 1 second. My dad says hi. Dad takes priority over you guys. You understand. All right, so I updated the thumbnail, and we're just waiting for the start of this thing. Apparently, all right. I was just reading this crawl here. Not Law Daddy, my actual father. Jerks. Yeah. Daddy's what I call Dick Ricada. No, that's different. Sorry. I don't know what I'm talking about. I'm as confused as a cop ordering food at Denny's. Reader's defense attorneys have argued that he's diagnosed with paranoid schizophrenia, which allegedly caused him to lunge at the judge after he failed to take his medication. Judge Holthus said Redden slammed her head against the wall before he grabbed her head and ripped someone. Well, if he didn't take the medication, it's on him, by the way. 31-year-old Deobra, I guess we're going with. 31-year-old Deobra Redden is accused of attempted murder, battery, yeah, extortion, technically, intimidation, definitely, and willful disregard for the safety of others. Yeah, that all sounds good. Yeah, extortion by it is technically extortion. It's technically battery. Yeah, it's all those things. Yeah, the county clerk or whatever that was next to him saved the judge's life. I know. When he jumped over the hearing. I don't know why we're doing opening arguments at 3 o'clock in the afternoon. I don't know. I don't know why we're doing opening arguments at 3 o'clock in the afternoon. I'm not the state of Nevada. What do you want from me? I don't know what the hell's going on. Yeah, if he didn't take his meds, that's on him. If he didn't take his meds, that's on him. To take his meds. Yeah, that's on him. And he wasn't paranoid. He's just lost his temper. There's no paranoia. He just lost his temper. I saw the video. The guy's going to spend the rest of his life in prison, man. Yeah. Deobra? Yeah, well, I mean, we'll pronounce his name however he prefers. That's fine. Although I'm not sure why we're giving him that much respect, but, you know, we'll give him that much respect. We'll try to pronounce his name the way he prefers. Mr. Redden. Or Mr. Redden. Yeah. Nevada, they don't wake up till 2. I know. Apparently not. I don't know. Although I have to say, I do kind of like their state seal. With the mountains and the sun peeking up behind it. And what looks like a little train scene here. We got a little bridge with a train over it. And then we got a little log cabin kind of thing with what looks like some ox and a cart. And then I can't quite tell what this is on the left-hand side. I think that maybe that's part of a tunnel. It looks like maybe a bucket on it. Can't quite tell. And then we got a little like milk and honey kind of scene at the bottom. I have to say, I don't really like what I assume are these roses at the bottom that are next to the words "all for our country." They kind of look like @ symbols on a keyboard. I don't like the way they look. And the way that they're spaced kind of looks weird to me. I don't know if they're supposed to be @ signs or if they're supposed to be cinnamon rolls or what's going on there. But the spacing and the drawing of it it isn't quite working for me. It's a mine. Yeah, it would make sense that it's a mine. Yeah. Any chance I could do Daryl Brooks sensing tomorrow? No commitments for tomorrow. No commitments for tomorrow, unfortunately. I'm traveling tomorrow. I'm a man of the land. I'm traveling. And so no commitment for tomorrow. So we probably will not see. Hopefully we'll just have opening. I mean, I feel like opening argument's really all I need to see of this trial. All I really need to see is opening argument, maybe closing argument, and, you know, what presumably the fastest guilty verdict ever. So, you know, because I saw it happen. I'm a changed man now, Your Honor. I'm changed. I'm totally changed. Well, I think maybe not. Leap. Darrell Brook is getting sentenced for something new. He's getting sentenced for witness intimidation. So, and a top on everything else. So, yeah, Mr. Grounds himself was facing new exciting charges, and apparently that came to a resolution. Did I see Richard Allen update in terms of the defense with respect to the Odinist thing not being allowed at trial? I saw the docket order on it. Yes. So apparently the defense does not have sufficient evidence for the defense to allow to go forward on that defense. So yeah, that makes sense. The video is enough evidence for the prosecution. Defense might call a medical expert. Yeah, well, we're gonna see that we're gonna have the video, and we'll presumably have the judge, and presumably the clerk, and presumably one of the police officers who was there, and presumably some other people who were there as the state's witnesses. And I can wrap this thing up myself. It's a plow, a mill, and a tunnel into a mine, and a train flanked by two groups of mountains. Well, I got the train part. Is that him in the suit? Oh, look at him trying to be respectful. Try to please pronounce Nevada right. Nevada.
Are we ready to proceed?
Nevada.
You wanted me to read this instruction before you gave your opening.
It needs to be read before we introduce the evidence. I don't know what Mr. Arnold's preference is as to whether it's read before opening.
It can be done with your introductory remarks, Your Honor. If you're reading instructions, because it is going to be introduced, like we said, probably off of the first witness.
It's Nevada.
So we don't want to
like
take
bad data?
And go ahead and, do the Travis,
Nevada.
Instruction.
Nevada.
Okay?
Nova. Neva.
Okay.
How do you pronounce it without the va?
Let's go ahead and bring the jury in, and I will read it.
The Silver
right
State.
after I finish my instructions.
The Silver State.
Do their opening. Okay?
Thank you, Your Honor.
AG. AG versus Deobra. AG versus Deobra. Oh, Lord. Hey, two dogs, Mom. How are you doing? Nevada. No, Nevada. And I got a DeVita, baby. I'll tell you what, if I ever become a part of the state, I'll learn how to pronounce it properly. If I ever move there, I'll learn how to pronounce it. Nevada. Nevada. Nevada, Dava, Nevada, Diva. Ooh, do, do, do.
I'll press it, Your Honor.
Just now learning Texas. That's true. That's true.
Will counsel please stipulate to the presence of the jury?
Yes, Your Honor.
Defense
Right.
does.
You may be seated.
Guys, at the end of the day, we should just let you know.
Ad not ah. Nevada. 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 Nevada, not Nevada. Nevada.
Ladies and gentlemen,
Is Nevada versus Nevada?
no juror.
You
may
say
be
Nevada,
held
I say
juror
Nevada.
relating to this case as of his or her own knowledge. And if any juror discovers during the trial or after the jury has retired that he, she, or any other juror has personal knowledge of any fact in controversy in this case, he or she shall disclose such situation to me.
Nevada, potato, patata. Let's call the whole thing off.
During the course of this trial, you are acquainted with the facts of this case or the witnesses, and you have not previously told me of this relationship, you must then declare that fact to me. During the course of the trial, the lawyers for both sides are not permitted to converse with members of the jury. These individuals are not being antisocial. They are bound by ethics and the law not to talk to you.
It also bears the distinction of being the state that's been the most nuked.
You are admonished additionally, you are not to visit the scene.
That's how much we like your state. We nuked it the most.
Mention of during this trial, unless specifically directed to do so by the court. What that also means, when I say no investigations or to visit the scene, I mean you don't just not do it physically.
What kind of sentence? Life.
By using your handheld
Life.
devices.
Attempted murder, man.
iPads, your phones. You don't Google Earth. You don't do any of those kinds of things. Everything you are going to learn about, you're going to learn about within this course.
I believe I can fly. I believe I can touch the sky. Think about it every night and day. Spread my wings and fly away. I believe I can soar. See me running through that open door. I believe I can fly. I believe I can fly. I believe I can fly.
Or actually, a second amended indictment. The clerk will now read the second amended indictment to the ladies and gentlemen of the jury and state the plea of the defendant to that second amended indictment.
District Court, Clark County, Nevada, the State of Nevada plaintiff versus Deobra Redden, defendant, case number C24
Nevada.
558-1,
Nevada.
Department 22, second amended indictment, State of Nevada, County of Clark, the defendant above named, Deobra Redden, accused by Clark County Grand Jury of the crime of attempt murder, victim 60 years of age or older, committed at and within the County of Clark, State of Nevada, on or about the 3rd day of January 2024 as follows. Count 1, attempt murder, victim 60 years of age or older, feloniously and with malice aforethought, attempt to kill Judge Mary K. Holthus, who is 60 years of age or older, to wit, during rendition of sentence, and once he knew she was about to sentence him to prison, did leap over defense counsel table into the well of the courtroom, thereafter rushing towards the judicial bench and jumping over it Superman style.
Yeah, Superman style's actually in the formal indictment. That is the best part of my day, man. That is the best part of my day. They literally put Superman style in the indictment. Let's go!
Landing directly on top of her and immediately attacking Judge Mary K. Holthus by grabbing her, pulling her hair, placing his hands around her throat, and or hitting her on the head by manner and means unknown. Dated this 3rd day of September 2024, Stephen B. Wolfson, Clark County District Attorney, by Elizabeth Mercer, Chief Deputy District Attorney, to which the defendant has pled not guilty to.
Please understand that the second amended indictment is simply a charge, and it is not in any sense evidence of the allegations it contains. The defendant has pled not guilty to the second amended indictment. The state, therefore, has the burden of proving each of the essential
Superman style in the indictment. It is part of the official legal instrument. Love it.
The purpose of this trial is to determine whether the state will meet that burden. The trial will proceed in the following order. 1, the parties have the opportunity to make opening statements. What is said in opening statement is not evidence. The statements simply serve the purpose of an introduction to the evidence which the party making the statement intends to produce. 2, the state will introduce evidence in support of the indictment.
This guy is so incredibly and totally screwed. It's hard to contemplate how incredibly screwed he is on every possible level. But, you know, we'll do it for whatever value it has. That's fine.
This is the defendant's case in chief. If the defendant presents evidence, the state may present rebuttal evidence. 5, if the state presents
I'm going to
rebuttal
up the
evidence,
D-reverb to 6, so let me know if it's too overprocessed. But I'm going to up it just a little bit more from 5.5 to 6 to see if it removes any more reverb. But let me know if it's too overprocessed and I'll bring it back down.
Or in the instructions, which I will read to you after the evidence, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your oath to base a verdict upon any other view of the law than that given you by me. 7, after the instructions on the law are read to you, each party has the opportunity to present closing argument in support of their case. What is said in closing argument is not evidence, just as what is said in opening statements is not evidence.
This better be the best opening statement ever. This had better be truly a 10 out of 10 opening statement from the defense. This had better be the best opening statement in the history of opening statements.
And determine the facts. Under our system of criminal procedure, you are the sole judge.
Unless the only other thing that could happen is the prosecution trips over their shoelaces. So one of those two things: prosecution trips over its shoelaces, or the best opening in the history of openings. I don't have a lot of hope for the defense on this one.
Determining the facts diligently and conscientiously, for ordinarily there is no means of correcting an erroneous determination of facts by the jury. The parties may sometimes present objections to some of the testimony or other evidence. It is the duty of a lawyer to object to evidence which he or she believes may not properly be offered, and you should not be prejudiced in any way against the lawyer who makes objections on behalf of the party he or she represents. At times, I may sustain objections or direct you disregard certain testimony or exhibits. You must not consider.
You think he takes the stand and he says, "Watch me crank it, watch me roll"?
Instructed you to disregard. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Remember, statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate or agree as to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must not be influenced in any degree by any personal feeling of sympathy.
I'm a bad man. I'm a bad man.
Both sides are entitled to the same fair and impartial consideration. In considering the weight and value of the testimony of any witness, you may take into consideration the appearance, attitude, and behavior of the witness, the interest of the witness in the outcome of the case.
I am swearing to it.
The relation of the witness to the defendant or state, the inclination of the witness to speak truthfully or not, and the probability or improbability of the witness's statements, and all of the facts and circumstances in evidence. Thus, you may give the testimony of any witness just such weight and value as you believe the testimony of the witness is entitled to receive. There are two kinds of evidence: direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw, heard.
Did I get some of the stuff that Nick had? No, I'm just in a good mood today. I'm in a good mood today, and I'm gonna ride it, baby. I saw this pop up in my feed, and I got so excited because it was unexpected. The reason I'm so excited is because this was unexpected, right? I just was strolling through my feed, and it popped up, opening arguments, like at 5 till, and I was like, I can't believe it. I can't believe it. And so I'm just so happy because it's just by circumstance, you know. It was a pleasant surprise that benefited my day. So hey, I'm a happy man.
It has just snowed, and you see this beautiful blanket of undisturbed snow. Now, it's pretty well lit because we've got a full moon up there. So you got a full moon, you got this beautiful blanket.
We're explaining what inferred evidence is.
As you're looking at the scene,
That's fine.
you happen to see a bunny hop through the snow. That is direct
Hippity hoppity.
evidence that the bunny was there. You saw
Hippity
it.
hoppity,
You saw it.
Easter's on his way.
Okay. I'm going to take you back. Full moon, dark sky, shining on this.
What happened to
beautiful scene.
what happened to the ground is wet, therefore it was raining?
The snow is not totally undisturbed.
I guess it doesn't rain that much in Nevada, so we have to come up with a different example. Does it snow more than it rains?
But it's fresh trash.
It might.
You can
Although it
infer-
probably doesn't snow that much in Nevada, in Clark County either, to be honest. When was the last time that it snowed in Clark County?
They're both direct and circumstantial.
When was the last time they had Christmas? Snow for Christmas in Las Vegas? It's probably been a while.
To decide how much weight to give to any evidence. No statement, ruling.
I think it's happened within my living memory, but
The course of this trial is intended to indicate my opinion as to how you should decide the case.
it is definitely not the same judge.
It
It is 100% not the same judge. There's no way it's the same judge.
I may even ask questions.
That
of
would be
witnesses.
impossible.
If I do so.
Although
it
they
is
do
for
look a lot and sound a lot alike, I'll give you that, but it can't possibly be the same judge.
And not in any way to indicate my opinion about the facts or to indicate the weight I feel you should give to the testimony of the witness. I may also find it necessary to admonish the lawyers. And if I do, you should not show prejudice or against the lawyer.
No, they just look a lot alike and sound a lot alike. It's definitely not the same judge. That would be impossible. That'd be the most biased judge ever. She's a necessary witness. The crime happened to her. She's definitely not on the bench. They do sound a lot alike, though. I'll give you that.
With your fellow jurors. It is important that you keep an open mind and not decide.
They have a different kind of snow in Las Vegas. I've seen those movies.
The case has been submitted to you under instructions from me. If you cannot hear a witness, please raise your hand as an indication. I might note we do have earmuffs that can amplify the sound if you are having problems hearing. And the only thing I ask that you do is that when we're not in session, whenever I'm talking to the lawyers privately under the white noise, I'm going to want you to take it off, because literally you're going to be able to hear what's going on the tables of the lawyers, and you're going to be able to hear what's going on up here, and you're not supposed to hear that part. Okay? Also, I plan to have regular bathroom breaks about every hour and a half or so. I try and peg it so I'm not interrupting witnesses or so forth, but sometimes I may do that. So I'll time it to be right in the middle of the session. But I do appreciate nature calls sometimes, and you just really, really got to go. Just raise your hand as an indication, and we'll go ahead and take a break right there. Okay? I may, during the trial, take notes of a witness's testimony. You're not to make any inference from that action. I am required to prepare for legal arguments of counsel during this trial, and for that reason I may take notes. Again, let me remind you that until this case is submitted to you, 1, do not talk to each other or anyone else about it or about anyone who has anything to do with it until the end of the case, when you go to the jury room to decide upon your verdict. 2, anyone else means members of your family and your friends. You may tell them you are a juror in a criminal case, but don't tell them anything else about it until after you've been discharged as jurors by me. 3, do not let anyone talk to you about the case or about anyone who has anything to do with it. If someone should try to talk to you, please report it immediately through Officer Black. 4,
Why has he got to be black?
or articles or listen to any radio or television reports about the case or about anyone who has anything to do with it. And again, that means you don't use your handheld devices to check me out or the lawyers out on Facebook or anything like that. Everything you will learn about this case, you're going to learn inside this courtroom. A trial is a search for the truth under the rules of law. Therefore, the court will allow members of the jury to ask written questions of any witness called to testify in this case. You are not encouraged
On a
to
scale
ask
of guilty,
questions because that is the
how guilty is he?
responsibility of the lawyers. Nevertheless, if you believe that an important question has not been asked or that an answer needs clarification, you may submit a question. Keep in mind, a witness scheduled to testify later in the trial may be the best person to answer that question. A question may be asked in the following manner. Please write it down and pass the paper to Officer Black. Make sure your juror number is on that piece of paper. Copies will then immediately be made for counsel and me as the presiding judge. I will then privately confer with the lawyers at a convenient time and then decide if the question is appropriate under Nevada law. Also, when you submit a question, make sure that you are submitting it while we are taking in the evidence. That is when the witnesses are testifying and the exhibits are being admitted. If you start asking the questions during opening statement, we can't help you there. And most certainly during closing argument, we will not be able to open up the evidence to have that question answered. Okay? If the question seeks factual information from the witness and is designed to clarify information about the issues in this trial, I, the presiding judge, or the lawyers may question the witness regarding the points raised in the juror question. No emphasis should be placed on the answer to the question merely because the question came from a juror. If a question submitted by a juror is not asked, no adverse inference can be drawn. The question was simply not allowed under the Nevada Rules of Evidence. And
I would like to give this opening statement for the prosecution. I'd like to give this. This is so easy. I could do it off the top of my head without breaking a sweat.
Yeah, sure.
Okay. If there is anyone present who expects to be called as a witness, please leave the room. Remain available in the hallway and do not discuss your testimony or the testimony of any other witness with anyone except the parties to this lawsuit and their lawyers. Okay? And counsel, do you have any, we talked about the admissibility of exhibits before. I'm going to go ahead and the parties have stipulated to the admission of certain exhibits. That's just to save us some time so they don't have to lay the foundation for it. States exhibits 1 through 33 and 40 through 61 are admitted.
Okay.
Okay?
Well, that's a lot.
And I have an instruction to give you.
That's a lot of exhibits that just got admitted. That's a lot of evidence that got admitted just now. 1 through 30 and like something through 60. It's like we just admitted 50 exhibits just now. Wow, that's good. Okay, you're toast.
Or to prove that he has a disposition to commit crimes. Such evidence was received to provide context to the events upon which the charge is based, and because it was not possible to admit other relevant evidence.
Defense knows they're screwed.
At the same time, exclude evidence of other crimes.
Poor defense lawyer. On the plus side, there's not a lot of pressure for him because it's so low. I mean, that's nice. So on the plus side, not a lot of pressure for the defense lawyer. It's like, you know, well,
All right, counsel.
just practice for me. Yeah. Oh, we got a PowerPoint? Or are we just going to play the video? That's the first thing. We're just going to literally play the video right off the gate. Is the opening literally just going to be, I'm going to play the video?
Do you have your microphone on? I'm about to turn it on right now.
Oh, did he make statements too? Oh, he did. I think he did make statements too. I seem to vaguely recall this. This is good.
I tried to kill a judge today. Those were the defendant's words mere hours after he violently attacked Judge Mary Kay Holvis in this courthouse on January 3rd of 2024 in courtroom 3F.
I'll do it.
In accordance with the laws of the state of
Yep. It's going great. It's going great. It's going really, really well for the defense.
Is she okay? Hey, radio somebody? Fucking radio somebody!
Yep.
We're all here today because of that attack.
Yep.
Judge Mary Kay Holvis is here today because of the bravery and intervention of 6 men. Her law clerk, Michael Lasso, Correctional Officer Joseph Cabralda, Chief Deputy District Attorney Jory Scarborough, Chief Deputy District Attorney Richard Scow, Marshal Shane
Call
Brandon,
his defense lawyer as a witness.
Court Marshal in Department
Do
18,
it.
where this event occurred,
Call his defense lawyer as a witness.
and
Do it.
Colonel Ben
Do it.
Lockhewer, who is the court marshal
Do
in the
it.
courtroom next door.
State, call his defense lawyer as a witness.
On the date of this incident, Judge Mary Kay Holthus was 62 years of age. She had been a judge since 2019. She had a mixed caseload, which meant she heard both civil matters and criminal matters. January 3rd of 2024 was a Wednesday, which meant it was a criminal calendar day. In anticipation of her calendar, she went through her calendar before the calendar actually occurred. Mr. Redden's case was obviously on calendar that day. She reviewed the relevant information pertinent to Mr. Redden's matter, which was on calendar for a motion to quash bench warrant and rendition of sentence, meaning he was supposed to be sentenced in front of her. The information she reviewed consisted of his pre-sentence investigation report. That report provides her important background information about Mr. Redden, but also the facts of the underlying offense. She made some preliminary notes. There was nothing particularly unique about Mr. Redden's case. Then her criminal calendar occurs. When Mr. Redden's case gets called, it's approximately 11:10 in the morning. A little more than halfway through her calendar, which began at 9:30 a.m. When the case gets called, initially, everything is going normal. You'll hear that typically with criminal sentencing, the state gets to argue first. Then a defendant is free to make a statement if he wishes to. In this case, Mr. Redden did. He argued for probation. He presented the court with information that he believed mitigated against a term of incarceration. After Mr. Redden was done, his defense attorney, Cesar Almasi, also made an argument to the court, seeking probation on his behalf. After Mr. Almasi was done, but prior to Judge Mary Kay Holthus having the opportunity to impose the sentence that she believed was appropriate, she made a comment, and that comment was interpreted by many people in the courtroom, including Mr. Redden, as indicating that he was not going to receive probation. After that comment was made, and before she imposed the sentence, Mr. Redden jumped over defense counsel's table, which was approximately 2.5 feet tall and 3 feet deep. He then bolted towards Judge Mary Kay Holthus's judicial bench. As you can see from this picture, the courtroom is set up differently from how this courtroom is set up. There's only one entrance and exit to the judicial bench in that courtroom. He then launched himself 4 feet, more than 4 feet, in the air, and tackled Judge Mary Kay Holthus like she was a football player. He then, once was over the bench and made contact with her, pulled her by the hair as hard as he could, and yanked her to the ground like she was a rag doll.
Yeah, pretty much. Pretty much. That happened.
When she testifies, you'll hear that she remembers being struck in the head, but she doesn't remember how it happened. She doesn't remember if it was an intentional act by the defendant, whether her head hit something, an object nearby during this altercation. But she remembers being jolted and frightened. She was trapped. This is the judicial bench in that courtroom. That entrance is the only entrance to or from where she sits when she presides over her calendar. And the altercation that you saw in the first clip happened right there. She had nowhere to go. She was terrified. She knew that she was no match for his physical strength.
Yep.
So she hid. She hid as far away from Mr. Redden as she possibly could. She crawled into the corner of that bench and waited there until the entire thing was over. When you watch the full video, you'll see that it took approximately 3 to 4 minutes before Mr. Redden was moved from that location. She was so shaken up, you'll hear, that initially she tried to climb that wall that you see in the picture and exit her courtroom where her court clerk sits. That's not an exit. But she did not want to be near Mr. Redden, and Mr. Redden was still in the entrance when he was eventually apprehended. Michael Lasso was the first person to intervene on her behalf because he was situated closest.
He looks like he has no remorse because he has no remorse. He has no remorse. He's a monster.
For several months now,
He's a monster.
I'll tell you about what his job duties are as a law clerk.
He has no remorse. He sees himself as the victim.
He is also a close family friend.
His mama, or whatever was his sister, like that evening, basically blamed the judge. And there's no accountability by these people. Literally. I watched them.
He was supposed to be at work that day. Fortunately, he changed his mind and decided to go in. He will tell you that among his many job duties as his law clerk, or as her law clerk, is he sits next to her during the calendars in case something comes up that she needs help with. Thankfully, on this day, he was situated exactly where he needed to be, to her left in that courtroom, as she presided over criminal matters. He was answering emails, performing work, and also paying attention to what was occurring on the calendar. He first realized
He'll be
that
blaming the system as he's in prison for the rest of his life. He'll be blaming the system and blaming the man.
Judge Holthus made a comment, and her marshal moved closer to Mr. Redden. You will hear that.
Hope you
when
enjoy wearing
her
that
marshal
suit,
moves
probably the
closer
last
to
time.
a defendant who appears out of custody for sentencing, that generally means that defendant is about to be remanded into custody. When the marshal moved closer to Mr. Redden and started to unclasp
Thank
his
you,
hand,
Adria, the wholesome $2. I can't believe they put Superman on trial, shaking my head. I feel
Mr.
you.
Redden bolted
I feel you.
over defense counsel's table.
I want to put on
and
text-to-speech and see how well that goes for super chats.
that
Probably not
perhaps
well. Let's give it a shot.
Mr. Redden was trying to exit.
All right, how do I
out
do this?
one of these rear exits in the courtroom that staff use. But it became apparent to him pretty quickly that his intended target was Judge Mary Kay Holthus.
Let's
And
see.
when you watch the video, you'll see the surprise, the shock in his eyes as he's watching this occur. He remembers Mr. Redden launching himself directly at Judge Holthus and knocking her out of her chair with such force that her head hit the tile wall behind the bench. He immediately knew that he needed to take action because he was frightened for her life and he was frightened for his own life. So he lifts Mr. Redden off of Mary Kay Holthus because he's the closest person to her. He got some assistance along the way, and the first person to come to his aid, and Judge Holthus's aid, was Correctional Officer Joseph Caralda. You will hear that on this date, he was assigned to the Field Services Unit at the Clark County Detention Center. That means that he's one of the correctional officers that's responsible for transporting inmates to and from their court hearings. He's also responsible for documenting the outcome of those hearings. So he was seated in the witness stand in that courtroom, which is directly next to the judge, but there's no doorway between the witness stand and the judge's bench. So when he saw the defendant go for Judge Mary Kay Holthus and tackle her, he had to climb over that wall to get to the point where he could assist. When you watch the video where the yellow circle is, that's Officer Cabralda climbing over the wall. At this time, Officer Cabralda was the only correctional officer remaining in the courtroom because other correctional officers had just done what they call a download, which means moving defendants who were already done with their cases back to the detention center.
Well, I think I have TTS with Kofi Oh, I could do TTS with Kofi. Let me try that.
Mightily trying to get control over Mr. Redden. That Mr. Redden resisted both he and Mr. Lasso and everyone else that came to their aid very hard. At some point, Mr. Redden was able to knock him to the ground. At which point, Mr. Lasso and Mr. Scarborough began to work even harder to get him off of Officer Cabralda, because Officer Cabralda was armed back, which could have presented a whole new set of problems. Mr. Redden continued to resist, which is why you see Officer Cabralda and Officer Lasso striking him over and over again, because they needed to get him to comply, and he was not getting it. He was still struggling to get away from them, struggling to get back to Judge Holthus. Eventually, they do get him under control, and Officer Cabralda actually uses one of Marshal Shane Brandon's, well, his actual set of handcuffs. He gets one cuff on Mr. Redden, but Mr. Redden is still resisting, so it takes an additional marshal before they can actually get him into both arms into the cuffs. Chief Deputy District Attorney Jory Scarborough was in the courtroom that day because he had another matter that was on calendar, not Mr. Redden's case. He's assigned to a specialty unit at the Clark County DA's office, the gun crimes unit. And you'll hear that as a specialty team deputy, he makes multiple court appearances in a day, oftentimes. So he arrived at Judge Holthus's department at around 10 a.m., and he was still present, waiting for his case to be called when this broke out. Again, he was partially paying attention, partially not, but he got the gist that Mr. Redden's case was on for sentencing. The state wanted prison time. Mr. Redden wanted probation. And then he figured out that Judge Holthus was not going to give him probation. He remembers, like Mr. Lasso, watching Marshal Shane Brandon move closer to the defendant. He looks down to do something else. And when he looks up, he sees that the defendant has already cleared defense counsel's table and is running full speed and hurling himself at Judge Mary Kay Holthus. Like Mr. Lasso and Officer Cabralda, he immediately knew that he needed to assist. So he went around the witness stand, climbed over the same wall that Officer Cabralda climbed over, and tried to wrap his elbow around Mr. Redden's neck to gain compliance. It obviously didn't work initially. He'll tell you that Mr. Redden was elbowing him repeatedly and trying to buck him off so that he could get back to Judge Holthus. But with the assistance of Chief Deputy Richard Scow.
Okay, hypothetically, if you donate $5 or more now on coffee.com/uncivillaw, your comment will be read out loud automatically.
From both Michael Lasso,
so we'll see if that works, if that ever happens. We'll give it a shot.
Mr. Redden was under control. Their first thought was to check on Judge Holthus. When they checked on her, they saw her still curled up in the fetal position underneath her bench. And she looked terrified. She was frightened, disoriented, shaken. And that really struck Mr. Lasso because he's known Ms. Holthus his whole life. And he's always thought of her as a tough cookie. But in that moment, she was scared.
New donation from someone.
Marshal Shane Brandon, as I mentioned earlier, is assigned to Department 18. He's been assigned to that department for approximately 2 years. As the court marshal, he is responsible for
test worked at least
order and safety in the courtroom during calendars. Because of a previous incident that he had where an out of custody defendant tried to flee from the courtroom it became his practice to stand exactly there. The doors behind him that you see in this photograph are the...
This is fine. I mean, she's walking through every single witness.
So
It's
he
fine.
did
It's not
prevent
exceptional.
defendants from
but-
fleeing the courtroom.
The case sells itself, so. Short of her literally tripping over her shoelaces, she should be fine.
He realized that Judge Holthus was not going to give Mr. Redden probation. So he made his way directly behind Mr. Redden, at which point he intended to handcuff him to remand him into custody. He unclasped his handcuffs, and immediately Mr. Redden bolted across defense counsel table.
She does have to demonstrate the intent to murder.
You'll see
So she has
that
to demonstrate it, to show that the intent to
Mr.
kill.
Redden hops the table, but
So
court-martial
it's a little long.
walked around.
It's a little long. She doesn't necessarily have to walk through every single witness. She could have just played the video really and just be like, you'll hear from a whole bunch of witnesses and just summarized them real fast.
In his pursuit of
Probably
Mr.
would have been slightly more effective, but this is
Redden,
fine.
he was about to grab his legs as he was
Well, wrap it up a little bit.
He tripped or somehow fell, and when he fell, he sustained a huge gash to his forehead that required 25 stitches. In addition to that gash, he severely injured his shoulder. He didn't initially notice that his shoulder was injured until he
Charged him with intent to murder. They certainly did. Yes, they certainly did. Apparently said, I tried to kill a judge today. So that'll do it.
At that point, he realized there was something severely wrong with his arm. He had to have shoulder surgery and was placed on light duty until just a few weeks ago, when he returned to full duty. He doesn't remember a whole lot of the incident, not surprising. But when he stood up and realized what was transpiring, even after he couldn't get over the bench because of his injured arm, he walked around the
The
desk
Ko-fi link is right where the pause sound control and that red line is if you want to rewound it.
as best he could.
So her press it, those things are in the way.
He passed his handcuffs off.
I don't know if that's enough reason to move it or not, but I'll think about it.
New
Noted.
donation from someone.
Mr. Redden.
Thank you.
Eventually, court staff in Department 18 alerted the marshal next door to the emergent situation that was occurring in Department 18. He is the court marshal assigned to courtroom 3E, which is directly to the left of Department 3F.
I could move it so it's like in the top right corner and drops down.
Court staff walked into the courtroom. They were in session, just like Judge Holthus, and said, "We need you now. It's an emergency. Please come now." So he walked out one of the
How about
rear
that?
exits
Is that
of the
better?
courtroom, like that, and then walked into the rear exit of the courtroom where these events were unfolding. When he walked in, his entrance into the judge's bench area was blocked because her chair, the law clerk's chair, had all kind of piled up right there. He moved them, and when he got to Mr. Redden had one handcuff in the cuffs and one still loose. He was still resisting very hard, and they were struggling to get the cuffs on him. So he took control of the loose arm so that the other individuals could get him in handcuffs. Once the
Didn't read the message.
defendant, Mr. Redden,
I didn't even see a
finally
message.
to the point where they felt comfortable relocating him, he was taken to the holding cell just to the side of where the court staff sits.
Let's see what it
And
was.
once he was in the holding cell,
Okay.
Marshall.
This is a test. This is only a test to one of people. Those people blab on and on without really saying anything. It wastes people's time with banalities.
To document when
Yeah, I
they
didn't
were
read
in
it.
the courtroom.
That's interesting. I'm not sure why. Thank you for the donation. Thank you for the $5.
I think it's the blue jeans, Your Honor. I think it's somebody on blue jeans.
Interesting. It didn't read it for some reason. I don't know what that's all about.
Oh, it's somebody on Blue Jeans, can you hear them?
Okay, so now there's some sort of problem in the courtroom.
What?
Somebody put some inappropriate
a video on there. It was inappropriate.
Okay, we may not be doing blue jeans or Zoom during the hearing, if that's going to happen.
Yeah.
Okay, I'm sorry, counsel,
It's okay.
and I'm sorry. This has never happened. At least not while I've been on the bench.
It was the first time for
Okay, so apparently someone decided to like try to play something inappropriate through Zoom, and it played in court.
Mr. Redden
So
sat
that's nice.
outside of the courtroom for approximately an hour or so before Marshal Bachhuber, Marshal Rollinson, and their lieutenant escorted
No,
him to
I
County
don't go to
Detention
court. It's not my practice area.
Center. That it's the court marshal's responsibility to book an out of custody inmate who was remanded into custody, which is why they had to do it. So they walked him over to the Clark County Detention
No,
Center.
no, no.
Where he began the
The
booking
video
process.
wasn't inappropriate. Someone apparently was trying to transmit something through Blue Jeans, which apparently is a Zoom kind of application. So someone was trying to interject something into the court
Thomas Cabrera.
from outside. So, good
During the
times.
process, an inmate sees both site and classification. And that's done for the purposes of determining where to house these individuals. When Mr. Redden was seen by site on January 3rd of 2024, he reported homicidal.
I wonder why
ideation.
your message didn't read out loud. That's very weird.
The report indicates.
Is it because it came from Twitch? It shouldn't matter.
Patient stated, only the judge. She sentenced me to prison.
No, that's weird.
Planned to harm her. He also denied thoughts or.
Why didn't your message get read out loud? I don't know. That's weird.
Or anyone other than the judge who sent him to prison. Ultimately, because of his expression of homicidal ideations, they determined it would be best to house him in Unit 2C. You will hear that Unit 2C is the unit where they send people with homicidal ideations, among other things. But with regards to his classification in 2C, it was because of his statements.
Interesting.
So Officer Darren Meekum and Thomas Cabrera went to transfer release, where the defendant had been waiting for classification. They were tasked with the responsibility of getting him dressed out into his Clark County Detention Center uniform, as well as performing what they refer to as a strip search. You'll see the video of them in the area, but there's no audio. Officer Darren Meacham is the taller individual standing at the front. Officer Cabrera is the individual off to his left. And when they walked into the cell,
New donation from Tammy Lee.
person cell,
Thank you, Tammy.
he was by himself.
Maybe it doesn't read the message. Maybe it just reads the donation, the fact there's a donation.
They
Thank you,
gave him
Tammy.
his hands, told him what they were there for, and he spontaneously stated to them,
I can just read them, I
"Sorry I'm
guess.
moving so slow. I'm kind of sore today. I tried to kill a judge."
Tammy says, I hope you're having a great day. I am. Thank you, Tammy. I appreciate it.
Those statements that Mr. Redden made and that violent attack against 62-year-old Judge Mary Kay Holthus are the reason that we're all here today. And when the state is done presenting its evidence, we are going to ask that you return a verdict of guilty as to the only charge in this case.
Okay. It's over. Thank you. All right, defense.
Mr. Arnold?
What you got?
Thank you, Honor.
It's fine. It was fine opening.
Do you want me to get back on Zoom or now? Not right now. I want to make sure his presentation's unobstructed. Okay.
We're good. Sir?
May it please the court, counsel, ladies and gentlemen of the jury, thank you for your time and attention. 3.7 seconds. 3.7 seconds. That was when the officer claps, unclaps the handcuffs. My client heard it, turned and looked at him, and made a move for the bench. This all occurred in 3.7 seconds.
Yep. Okay, noted. Are you really going to play this during your own opening? Are you going to go for a saturation defense? Good luck. Yeah, I'm not. Okay, good luck. He's gonna he's gonna try to saturate it. Let me play the video so many times the jury gets sick of it.
7 seconds. That was
Okay.
not enough time for Mr. Redden to formulate the intent to kill Judge Holtis.
Yes, it is.
Remember what this case is about. There is one count of attempted murder. And for there to
Intent can be formed in an instant.
murder, there has to be intent. Intent to kill.
Yeah.
As everything else in life, the story didn't begin on January 13th.
Wow. Okay. This is an interesting defense. Okay. This I'm already thrilled. All right, my defense is let me play the video. And my defense is let me bring in my client's prior bad acts. Let me bring in my client's prior bad acts. Okie dokie.
This story actually occurred on April 3rd.
Sure, let's do this. It's
This
fine.
is when Mr. Redden was first arrested for what brought him in front of Judge Holtis. And basically, Mr. Redden was arrested for swinging a metal baseball bat at his brother-in-law.
This sounds suspiciously like a propensity for violence.
He was charged with assault with a deadly weapon.
Yeah.
He was also apprehended by the police, and he was taken into custody. When you're taken into custody, you're supposed to, within 48 hours, stand before a magistrate so they could decide the question of bail or not. Mr. Redden, on April 13th, told the officers that had him in custody that he refused to be transported. So he was just going to...
So he has a record of violence and a record of defiance of authority. These are very interesting points, defense counsel. More failure to leave his cell, refusal to be transported, more defiance of authority.
He failed to leave his jail cell again, and he says that he wasn't coming to the hearing. They had to continue the hearing. Again, on April 25th, Mr. Redden refused to be transported to the heading. Finally, the Justice Court Judge Jacinto, he did an order that says, by any means necessary, he needs to be present in this courtroom. So on April 26th, the officers got Mr. Redden, and he was present. The judge then, he's handed the charges. The judge asked him if he understood the charges. Mr. Redden didn't even respond to the judge's questions, even though he had a copy of the information, which was assault with a deadly weapon, on his person. And not only did he not answer the judge's questions...
So the judge asked him a question and he refused to answer.
In the court proceedings.
And he was disruptive to the judge, more defiance of authority.
Again, we have almost a week.
So let me get this straight. Your defense is my client attacks people with aluminum baseball bats. He refuses the orders from the jailers. He refuses orders from the judges, refuses to answer their questions.
At this
This is the defense we're going with.
is a public
Okay,
defender.
fine.
Then petitions the court to send him to what's called competency court. Competency court is a whole nother courtroom here in our building. And competency court is for people that do not understand the legal proceedings, are unable to assist their attorneys in their defense, or number 3, appear to have some kind of mental condition that prohibits them from acting properly in court. All those things were exhibited by my client, Mr. Redden.
Yeah, and he was cleared by that competency court twice, if memory serves.
And see if he can be restored to competency.
I believe they ruled him to be competent twice.
Competency is basically, we can't try you. We cannot prosecute you under the law, since you're not understanding what's going on.
I mean, clearly he's competent because he's sitting there.
Courtroom behavior, not helping your attorney out, we can't sit here and prosecute you. Go ahead. So, basically, he's found on May 23rd, he's sent to Lake Crossing. Lake Crossing is a mental institution here in town, and what they do at Lake Crossing is make sure that you're evaluated to test your competency. Sometimes, people are sent there and they have lingering symptoms like they're just making up, acting crazy. Other times, they sit there and evaluate someone and their mental instability is
I do like the fact that this court actually has like decent equipment. Their microphone for their witness. They got Sennheiser, man. This court spends some money on their equipment. This court has good audio. He's Sennheiser, man. Hey, I respect that.
Mr. Redden, he was evaluated and it was determined by Dr. John Paglini.
You see some muscle? Thank you. Going to the gym, getting buffer.
To this case, and in regards to his finding of incompetency, and there are other psychiatrists because there at least
Got a long way to go, but we're making progress.
Determination, and what they determined was he was incompetent to stand trial, and so he was given a course.
Competency is a very low standard, yeah. It's a very low standard.
During this course of medication, that would calm him down, bring him back to earth, bring him to a person that we can work with, that he can go to court, he can understand the proceedings, and not be disruptive in court. So, Mr. Redden, when you go back to that one, I just want to make the last point that he was at Lakes Crossing for 5 months. He was eventually found by the doctors on October 20th, 2023 to be competent to go ahead and proceed with trial. So exactly 5 months later. Go ahead now, sir. After he returned back to Justice Court, he was in front of Judge Jacinto. He had discussions with his attorney at that time, and they decided that he was going to go ahead and enter into a guilty plea with the state of Nevada. Again, now he's of right mind.
So he is of right mind.
His case with his attorney. As you can see, there was no courtroom outbursts or anything like that. And so much so, the judge released him on November 1st, 2023. He was released from custody. Okay? He returns to back to court, and now this is district court. This is in front of Judge Holtis. And on December 6th, he has no extreme courtroom behavior. He goes ahead and the guilty plea agreement's read to him. He answers a myriad of questions, and he pleads guilty to an attempt assault with a deadly weapon. The sentencing was scheduled for January 3rd, 2024.
I like Runkle. Ian Runkle's a cool guy. I wouldn't mind being on his channel. It's been probably a long time since I've been on Ian's channel. I mean, normally he does solo, but I love being on his channel. He's great.
Mr. Redden did not receive his medication that he had while he was here in Clark County Detention Center. What happened was he gets released and he's given a prescription. That prescription is supposed to be filled at the Mojave Health
The only
Center.
prescription I need
He calls
is more cowbell.
Testimony from Karen Springer. He made several attempts at appointments, called and attempted to get him in so he could take his medication. However, you'll see through the testimony, he does not get medication, and he doesn't get it for 2 months. So from November 1st to 2020, in November 1st, 2023 to January 3rd, 2024, a period of 60 days, He does not have his medication that put him in that state where we saw the appropriate behavior, what you're seeing today. And basically, he's under that medication that he had when he was in CCDC. And that's why he's displaying, good decorum, appropriate courtroom behavior. He's not going to wild out, and trust me, I'll tackle him if he tries to, do anything like that. But bottom line, that's not going to happen because he's medicated, he's calm, he understands what the proceedings are and what's going on right now. During this 60 days, Mr. Redden slipped back into his unstable mental state. The same mental state that he had when he was first arrested for assault.
This is incredibly funny.
And charged. And
this is insanely funny.
Attempted assault with a deadly weapon. Next.
It's insanely funny because he's insanely guilty, and this is so fucking dumb.
Unfortunate incident that happened on January.
If you're not laughing, you're not trying, man.
One thing I noticed, and I looked at this videotape several times from the very beginning to the very end. I know that all the parties involved. A simple question wasn't asked. And I'll explain later as to why it wasn't asked. But no one asked Mr. Redden, did you take your medication today? His attorney didn't ask, the prosecution didn't ask, nor Judge Holtis asked. I'm not saying this is anybody's fault. It simply wasn't done. So he comes into court and nobody knows what his real mental state is during that time. Nobody knows that for 60 days he's been having paranoid thoughts. Nobody knows that he's been staying at home, not going out into the public, and different other things that were discovered by Dr. Paglini that he'll discuss. Mr. Redden did not intend to kill Judge Holtis. The evidence will show that Judge Holtis, she hurt her head when she struck the wall that was directly behind her, similar to this wall. She also was hurt when she fell on the floor. You'll see pictures. She wasn't significantly bruised. She was bruised, but it wasn't significant bruises. And those were basically on the areas where she fell. She had no cut. She had no strangulation marks on her throat. There will be no evidence that anybody ever that saw Mr. Redden touch her throat. We'll have specific evidence of where his hands were placed right before he was pulled off of Judge Holtis.
Oh, no one saw his hands around her throat. Oh, that's definitely going to be the thing.
That he was intending to kill.
Wow.
And again, you always have to go back to intent. That is going to be the big question that you guys are going to have to deal with at closing. Did he have the intent to go ahead and kill? And we are going to submit that the evidence does not show there is any intent to kill Judge Holtis.
Wow. Nice.
Okay. Counsel approach.
Would you like to plead guilty now, sir? I'm just trying to find an update on what we've got here in terms of let's see if I can find evidence on him pleading to these other charges. He pleds guilty to 6 out of 7 charges. I'm just trying to find confirmation on that. I just find the headline, but I'm having trouble finding exactly what charges they pled to, or it also doesn't make sense. You can't be insane for some charges and not for other charges. Especially when they're committed at the same time. I mean, if there were differences in time, technically, I guess, but when all the crimes are being committed at literally the same time, you can't really have insanity for some and not insanity for others. I suppose you can to the extent you allow mutually inconsistent charges, but would you like to do a plea now? Would you like to do a little plea, maybe? A little plea of guilty? Since you're incredibly, insanely guilty. He has 3 felony convictions, surprising nobody that we're talking.
The attorneys were, let's say, a lot more efficient than we anticipated. So we're going to go ahead and finish for the day. I need you back here at 1 o'clock. And remember, you're all like brides. We cannot get started until every one of you are here. So during this period of time, you are all admonished not to talk.
This is hilarious. They're coming back for day 2. They're coming back for day 2, and they're starting at 1 p.m. This is the greatest court ever. We don't start at 9 in the morning. We start at 1 p.m. Come here after lunch, after brunch. You'll be fine.
Converse among yourselves or with anyone else on any subject related to the trial. You're not to read, watch, or listen to any report of or commentary on the trial by any medium of information, including without limitation newspapers, television, the internet, and radio, or form or express any opinion on any subject related to the trial until the case is finally submitted to you. And again, no outside experiments, no visiting the scenes of any of the events that you've heard talked about. Don't use your iPads to find out information about this case. Don't read the newspapers. Everything you will learn about in this courtroom. Have a good evening, and we will see you tomorrow at 1 o'clock.
1 o'clock. That is hilarious. 1 o'clock. What a courthouse this is. This is great. Yeah, yeah, now he's staring at the jurors, I know, right? And doing a little side eye for the jurors or something, yeah. Who is this guy, the black behind him with the suit? That's what what kind of glasses are these? Damn. People pimping it out in not New Vegas or not in Nevada. Damn. Shit. I would never wear something like that in a courtroom. Shit. Who wears that? Is he out on bail? No, he's not out on bail. He's been convicted and sentenced for other things. No, he's not out on bail. He's in custody. No. He's convicted of varying things. Yeah. Did I say New Vegas? I did say New Vegas. I did slip and say New Vegas. I absolutely did. 100% I did, yes. You caught me. I was just trying to find what charges he pled to and if we can find a record of that happening and what the terms of any plea was. Pled guilty to several charges. I'm just trying to find what he pled guilty to.
Has left the courtroom, and you may be seated. Norma, what exactly, do you know what happened?
I don't know what happened, but when I switched to Zoom, there was a very improper video.
Okay.
Someone was playing porn?
I want to be able to give the public access to the Zoom and all that. I'm just not, we've called IT about this?
I reported it, yes.
Okay. Never had this happen before, but apparently something very inappropriate went on the Zoom system. We cannot have that. And so anybody that wants to see this, definitely you might want to consider being inside the courtroom for that. And then we'll see what we can do on our end so it doesn't happen again. And I apologize again to you for that interruption.
Just for the record, at no point was that broadcast visually to the jury. Although it was audible, we couldn't really tell what it was, in my opinion. But visually, it was not in any way broadcast to the
Yeah, I couldn't tell what it was audio.
I don't think it was either. So, no, she was the only one. I didn't see it on any of my screens.
Yeah, it only came up on Zoom, which I only had access to it. Yeah.
Okay. All right, but anyway, we will try and find out what happened there. Okay. Okay, schedule 1 o'clock tomorrow. We'll have a full day on Friday, half a day on Monday, half a day Tuesday, half a day Wednesday, if we get into Wednesday. Okay?
We're doing a full day Friday, though, but half days every other day of the week.
Of course, the most important document is the verdict form that we will need to get through. If you guys could agree to as many jury instructions as possible, that will make our life a lot easier. Okay? Anything else that we need to take care of?
I don't think so, Your Honor.
Okay? All right. Have a good evening.
Thank you.
All right. Well, there you go. So apparently he pled guilty to battery on a protected person age 60 age or older, resulting in substantial bodily harm. So aggravated battery, essentially. Intimidating a police officer, battery on an officer, resulting in substantial bodily harm. Willful or wanton disregard for the safety of a person or property, resulting in substantial bodily harm. Battery by a prisoner, an unlawful act relating to bodily fluid. Well, that would be like spitting in her face or something. He admitted that he jumped over the table, ran across the courtroom, and launched himself Superman style at the district judge. So he obviously can't take the stand in his defense because all those statements can be used against him once he takes the stand. He also admitted spitting on the correction officer. The prosecutors dropped charges relating to extortion and battery on an officer. Fine. The defense apparently plans to call 2 witnesses towards trial, the foster mother and a psychologist. Prosecutors said they expect to call 10 to 15 witnesses, most of those being the people in the courtroom, presumably. And unclear what sentences are available as a result of those guilty pleas, but I imagine that's some serious time. So he's already been convicted, and he is facing, and he's already just now pled guilty to all these things, which I imagine is some serious time in jail. But pled not guilty on the basis of insanity, which would be equally a defense to all those charges, I would think. But okay. I'm just trying to see if I can find any information about the sentencing that will be for that. Can't find it readily. So in response to, okay, wait, no, this looks like something. Hold on. Give me a second. Listen.
Officer, he invoked his...
Let's bring in our guest for this.
I don't think he, Ted
Suffered from
I think
these
this is
issues, and it sounds like there will be medical.
I think this is referring to the previous thing where he was sentenced to like 19 to 48 months, I think, was for the offense that he was before the judge in the first place. Yeah. So he was sentenced to 19 to 48 months for the charge that he was before that judge for. And that was the sentence he did get. So he's been convicted of that, and then he pled guilty to 6 charges today, it looks like. And let's see if I can find any video of that. That'd be cool if we could cover. Not that I can find. So I can't find any video of him pleading, and I can't find any discussion of the sentencing for the charges for which he's pled guilty. But it's a difference between, 10 years behind bars and the rest of his life behind bars, or something on that frame, I would think. Just reading some additional things if I can find anything. The Ko-fi link not working is just your problem. That's fine. Don't worry about it. You guys are fine. We're just trying to make it work. It's all good. Don't worry about it. Was the original sentence? It was 19 to 48 months. Yeah, it was 19 to 48 months. So 2 years to 4 years, basically. And I was just trying to see if I could find any information about this was yesterday. It looks like this happened with this guilty plea. But I can't find any video of it. 19 to 48 years. Yeah. He's going to jail for the rest of his life. Is the bottom line, though. Yeah, I can't find anything. Okay. All right, guys, I guess I'm going to sign off for now because I can't find anything and I don't want to, like, just, you know, bump around and when I can't find anything. So, but, yeah. So I guess I'll go ahead and sign off. I probably won't stream tomorrow because I'm traveling, but I'll do what I can. And all that. So I'll see you guys later. Until later, my friends, I hope all's well. Cheers, my friends, for now, and goodbye.